I'm Bill Oughton of Oughton Claims Management.
I'm Chantal Roberts of CMR Consulting, and welcome to the Art of Adjusting podcast.
Today, we're going to talk about life as an insurance adjuster from the perspective of property, auto, liability, or workers' compensation adjusters. Our goal is to bring interesting topics in the world of claims adjusting to people who are working as an adjuster now and to people who are considering a career as a claims adjuster. Hey, Chantal.
Hi.
Good morning. Today is the 29th day of February, which is kind of weird. That only comes around, every 4 years?
Oh my God, you just ruined my joke because I was going to say, how often does that happen? And I knew you were going to do like the dad joke every 4 years.
Well, accuse me of doing a dad joke. Are you kidding me?
What? That's crazy talk.
It sounds just like me.
I know it, right?
So the topic today is actually kind of interesting, and it has to do with the effective dates of policies, which, kind of sounds like it might be really boring. However, when you're a big insurance nerd like us, we can make it really, really cool.
Absolutely. Or we could put people to sleep. I mean, they
yeah.
could use this as a sleep aid.
So when we talk about the effective dates of a policy, and we're talking primarily about property and casualty here, life insurance policies are a little different. But on the property casualty side, they're usually going to be a full year. Auto policies can go for 6 months, I think.
They can go 6 months, a year, and then I have seen some go 18 months, like when you're first starting out.
Got it.
But
Okay.
But yeah, and I mean, auto policies technically, I suppose, could go month to month. I mean, you're paying month to month, but it's written for either 6 months to a year,
Yeah.
which gets into the whole thing of why certificates of insurance may not be as wonderful as they are. But that's a whole nother podcast.
Yeah.
Mhm.
Well, the effective date. So today is a weird one because it's February 29th, and we can talk about how that might create an issue. But let's imagine that we had a policy that started on February 15th.
Right.
So the agent would likely have written that policy a few days before, maybe a week before, or just selected that date as the effective date. I don't know if it was like February 16th, could they make it effective February 15th? Only if the insured signed a no loss statement, right?
Right.
Okay.
Absolutely. Yeah, because there would be that concern that we are filing, or the insured would be lying to us, which I know is unheard of, but that there would be a claim, and that's the reason why they are getting insurance.
Right. So the
Right.
agent wants to make sure that their house didn't burn down and they had no insurance, and then they ran over to the insurance agent and said, "Hey, I need you to make a policy for me for 2 days ago because that's when my house burned down."
Hmm.
Um,
But leaving off that last part.
yeah, that's illegal.
Yes,
It
that would be
is a
fraud.
material misrepresentation at its best.
Yes.
And so in order for the agent to backdate that policy, they would just have to have the insured sign a paper that says my house didn't burn down
Right.
or something to that effect.
Right.
So that's how they get around that. Now let's talk. That's the beginning of the policy. Let's talk about the end of the policy where February 15th, 2025 would be the last day of the policy. If they paid their bill and the insurance company agreed to renew them, then it would just start a new policy period as of midnight, correct?
1201. And this is a very
12:01.
good point, while we're talking about policy effective dates and these sorts of things, because the date in question, February 15th, it begins on February 15th, 1201 midnight AM, where the insured resides. So for you, that would be Eastern time. For me, it would be, 1201 AM Central time.
Middle
And
time.
sorry.
Middle time.
Yeah, middle time, Middle Earth
I'm on right
time.
time, middle time, and left time.
Middle Earth time,
Middle Earth.
for all of our Tolkien nerds, I guess, but not that I identify with that at all. Anywho, um, so then the policy would end on February 15th, midnight
Midnight.
AM 2025.
Got it.
And why this is important is because every once in a while, and I have seen it happen probably 3 times in my career, where we do have a fire and we're wondering which policy to file it under. Do you file it under the 2024 policy or do you file it under the 2025 policy? And of course, for adjusters, the insured's not going to know. They're just going to, it happened around midnight. Well, that doesn't help me, you know?
Right, right.
For adjusters, that's when you're going to want to get like maybe the 911 records or the fire report, or of course, send out someone like Bill to interview the neighbors. Well, what time was it? It was about 11:30. Yeah, I know because the baby was crying and whatever. So
In the context of what I just explained, where there was a renewal of the policy, it really kind of doesn't necessarily matter because
true.
the only thing that might change is the policy limits. So they might have more, if they had inflation guard on there, which is increases your limit every year, it might trigger additional coverage that you might have the benefit of. But more importantly, if you were switching carriers from one carrier to another, then it becomes kind of a bigger problem because now you've got to sort out which company is responsible to pay for that fire loss.
Yes, absolutely. Yeah. And that happened to be at least one of the issues that I had. We were trying to figure out which company was going to be the one handling it.
Mhm.
And the other two that I had, it was just trying to figure out which one would be. And what we did in the interim so that the insured could be taken care of because their house did burn down, for any adjusters listening, is we opened 2 claims. One on the 2024 policy, for example, one on the 2025 policy. And I think we were billing everything out on the 2024 policy. And when I say billing it out, normally like Geico adjusters or Liberty Mutual, like if you're in-house, you don't necessarily bill out except if you put in a reserve for your independent appraiser or your CNO or something like that. But we were putting in all of our reserves for the 2024 claim. And if it comes to find out that it happened at 12:01 a.m., then that's when we moved everything over to the 2025 claim.
So here's an interesting scenario. A house fire, it's not like a button gets pushed and then the house fire happens and then
Boom.
it
Yeah.
stops. Chances are that house fire is going to spread from one end of the house to the other, or from the bottom to the top, or whatever.
Mhm.
And it's certainly possible that it could have started at, well, I'm sorry,
11
11:45 p.m.
a.m. or
and
p.m. Yeah.
p.m. and start and finished at, half an hour later
Mhm.
into the next policy period. So the damage to the living room and the kitchen happened under one policy, but the damage to the garage and a couple bedrooms happened under the second policy.
Mhm.
So that's not really what happens, though. I mean, we
No.
usually want to look at the time that fire started, and typically, like, I've never seen this argument raised, but we would always consider the date or the time actually that the fire started, and that's the date of loss.
Yeah. That's
Even
what.
if parts of the building were damaged into the other policy period, I suppose you could probably make a case that additional limits would be available for some of that other damage. But I don't know.
So
I've never had an experience where that has come up.
interesting concept. It a lot of attorneys have used that idea that if it goes over into a different policy, we do have additional policy limits available to us. A lot of our newer adjusters who may be listening don't remember 9/11. They weren't even born then.
Hmm.
And that makes me feel very old.
Yeah.
But um because there were 2 planes that hit at 2 separate times at 2 technically different locations, Tower 1 and Tower 2, I believe, if I recall correctly. They put forth that there were 2 separate claims. The attorneys put forth that there were 2 separate claims, whereas the insurers, the carriers, were saying this is one claim, this is one act of terrorism. The fact that they used 2 planes is neither here nor there. It would be like an arsonist setting 2 separate areas of fire. That doesn't constitute 2 claims. That just constitutes one claim. It also harkens back to that idea under earthquake claims that if you have a tremor or another earthquake within 72 hours of the first one, that's all considered to be one claim because earthquakes usually are in clusters. And also, fun fact, I just happened to be talking about this in the CPCU 530 facilitation group that I oversee for CPCU 530, which is legal environment. And they had a question like this, and we got involved. We started talking about, would you consider this claim to be one claim or two claims? And I think if that did happen, and it was in one house, I would consider it to be one claim. Now, if it was, for example, a commercial structure where the fire may have jumped from one apartment building to another, I might consider that two claims. It
Yeah,
just depends on how the fire moved, I think.
I think it can be challenging. And when there's questions of like this, I mean, these are ambiguities that
Yes,
how we decide those in favor of the policyholder because they
absolutely.
didn't draft the contract. But
Absolutely.
um, so putting my fairness hat on, that's the way I would approach most of these. But let's say you've got a policy that starts on February 15th and there's no coverage at all prior to that. And the fire starts at 11:45 p.m. And there's two separate buildings like you've described. Fire starts in one at 11:45 and at 12:15 it spreads to another building. You'd have to say that the first building was out of the policy period and the second building was inside.
Hmm.
That could be a very contentious claim, couldn't it?
Absolutely could be. And I think too, under your scenario, you're right. I think I would cover the second building, but not the first, under the guise of helping the insured uh, as much as possible. But let's go back and change the scenario just a tad, and then I'm going to bring it back to what you had said. If we had coverage in 2024 and we went over the policy period, so we can cover one building under 2024 and cover the second building under 2025. I don't necessarily know, even though I had said I would probably cover the second building as a second claim, if I necessarily would. It just depends on how that fire went over to the second building. Because I'm thinking of, and this is a liability term, guys, I want to make clear, even though we're talking about a policy, a property policy, about this ensuing loss. Do we have something that creates this second fire in the second building that would constitute a second claim? Or is it like the wind picked up and it's all like wildfire, for example? Because you wouldn't necessarily say your house is one claim and your shed is a second claim in the matter of a wildfire. Now, all of that being said and done, if we've got moving it back towards your idea of there was no prior policy, the first building wouldn't be covered and the second building possibly could be because the fire started after the policy effective date. It would be a contentious claim. I do want to ask you, because I know that we have some newer adjusters listening, could we expand on the idea of ambiguities and what an adjuster or carrier is supposed to do in the event of an ambiguity? Because we just really kind of glossed over that. And
Sure.
I just want to make sure that everybody knows that.
Yeah, the basic idea is that a policy, they call it a contract of adhesion. And that just means it's drafted by one party and presented to the other party on a take it or leave it basis. So the party that it's being given to, the policyholder, really has no say in how that language is crafted and what it says as far as the benefits they get and the benefits the insurance company or the things that help the insurance company out when there's a claim. The only thing they can kind of make a choice about is maybe deductibles. They might be able to choose policy limits to a certain extent. But the language, the contract language, they have no control over. So when we have a claim and there's something that's ambiguous, that means that we have to give the benefit of the doubt to the party that did not draft the contract, because they're kind of at a disadvantage in this scenario. So we're trained as adjusters to do that when we have a claim and make sure that we're giving the benefit of the doubt to the insured. And the way it's phrased is that ambiguities shall be determined in favor of the party that did not draft the contract, or something like that.
Yeah.
So, yeah.
In plain English, what this means when we're giving the benefit of the doubt to the insured, if we think that something may or may not be covered, like the building with the one building that happened before the loss and the second building that happened, or before the policy period, and the second building that happened after the policy period, then we've got an ambiguity. Is this all one claim? If we said yes, for example, it's an ambiguity. So in this particular instance, it would be best to extend coverage to the insured under that ambiguity, because that's what we're supposed to be doing. If the carrier had the last chance to reform that policy and word it the way they wanted to word it, and if they didn't word it correctly, then we got to give it to the insured. So that's an excellent example of that.
One other thing to think about in the scenario where where we've got two buildings and the fire crosses over physically and crosses over in time to the next policy, or to a policy that did exist. Imagine the same scenario where we have no coverage prior to the 15th. Fire starts 15 minutes before the clock turns midnight. The fire spreads to another building. All right. Now, let's say that first building has a limit of $1.2 million, and the second building has a limit of $50,000. Now, the insurance company is going to say, look, we're going to pay you for the second building because that is definitely in the policy period. We got cameras and we've got witnesses that all confirmed that the first fire in the $1 million building started before the policy period, and the second fire started after the policy period started. So we're only going to cover the $50,000 building. Do you think that one's going to go to suit?
Yeah. Yeah, that one's probably going to go to suit as well.
And I think in a case like that, what you'll eventually come down to is the veracity or the provability of the evidence that you have. You say you have camera footage. How do we know the dates on those cameras were calibrated properly and the times? You talk to witnesses. Is the witness you spoke with the cousin of the CEO of the insurance company, or maybe the cousin of the owner of the building? So all of those things are what makes claims really interesting sometimes.
Oh yeah, absolutely. Fun fact. Because I can hear everybody going like, "Oh, Bill, that never happened.
That never happens. You're
Blah blah
just making
blah."
stuff up.
Yeah,
I'm
you're
not
just
smart
using
enough to
these.
make this stuff up.
You're just using these really left field kind of examples. I'm going to give you a real life example where this actually happened. We had an arson. My husband was working or overseeing the adjuster who was working this arson case, and my husband said, "Hey, ask for any camera footage in the area, because we know that there is an arson. We got the gas thing, blah blah blah. It was pretty much confined to one area. The insured is in financial trouble. All of the red flags are there." And so the adjuster did ask for camera footage, and the insured gave it to him. And looking down the hallway inside of the office area that was supposed to be burning, you see the insured's son walk into the ladies' restroom where the fire started with a can of gasoline, and 5 minutes later come running out without the gas can, and you see a bright flash come across the camera screen. And we're like, "Oh my gosh, we've totally got that." The issue, of course, is the fire, according to the fire report, happened about midnight, and the camera said 11 p.m. So what you were saying about the insured not setting the time right or updating it for daylight savings or falling back or whatever, this is a perfect example. Besides the fact that arson is incredibly hard to prove, even though we saw the insured son, walking in and walking out and then a bright flash, you still can't really
You
prove
didn't
arson
say, yeah,
unless you have the camera going with match
the
to
lighter, yeah.
yeah, basically, yeah. So we ended up paying they ended up paying the mortgage holder. But anyway, just to show you just weird things, like we can't make this stuff up.
Yeah,
Facts are stranger than fiction in this particular instance.
yeah. And a lot of adjusters I talk to, they're like, boy, I should write a book about all the stories. And
Mm,
I think we all feel that way.
yeah.
And, we're probably would be breaching privacy things to disclose a lot of the stories that we have about various claims. But interesting idea on the clocks on the footage, the security camera footage.
Yeah.
I look through a lot of it every day, from
Mhm.
one claim to the next. And I always wonder about the accuracy of the time stamps on those. I've got a case going now where we have multiple cameras. I think we have 16 cameras.
Mhm.
And we're trying to track a person who is walking through a facility. We're trying to match up the times on the cameras. Now they seem to be pretty accurate. It seems like if you look at 11:39 on one camera and go to the 11:39 on the other camera, there's similar things happening.
Mhm.
But I always wonder, how do we prove that they're calibrated properly? That's something for a camera expert. We have a couple of people that I call on for camera related expertise, whether it's video or camera footage from a phone or a DSLR or whatever. The digital footprints that they leave behind can be very important to establishing when a photo or video was taken.
Very, very important. Yes. And I know we're talking leap years, which again deals with time. And I would encourage adjusters. This is not a job you can just dial in. I mean, this is something that you do literally have to be looking at. And I think another easy way to be able to do this would be if there's kind of like not necessarily a live streaming, so to speak, but if you could go in the back where the insured is recording this and look at the time that is being displayed on the display cameras, like the security cameras, screens, and see, yes, it says that it's 11:30, and you look at your phone or whatever, and it says 12:30. Well, then you know you need to back it up an hour, and that would be very good, by the way, FYI, to mention that in your report, put that in your notes to talk about that sort of thing. So yeah, these sorts of things are things you can't really dial or in. You do have to literally think about these sorts of things.
I think a lot of systems update that automatically. Again, how do you know it's perfectly accurate? I mean,
Yeah.
I've got clocks all around me right now. I've got my watch says 9:54, that says 9:55.
Mhm.
This says, what does this say? This says 9:55. And they're all connected to the internet.
Yes.
So, um, 1 minute can make a lot of difference. So,
Yeah. I mean, 1 minute means coverage on the 2024 policy and the 2025 policy. That is how detail oriented you have to be. But let's continue on with our
the
talk about
elephant in the
time.
room,
Huh?
the elephant in the room.
Yes. Okay, so we're talking about all of these things that can and can't happen. And I know our one listener that we have, the one listener that we have,
We love
hi
you.
Brandon, is saying, yeah, that stuff never happens. Let's go something, even stranger. 9 times out of 10, you're not going to have a policy that begins and ends on leap year because it happens, every 4 years or something like that. I bet, it's something that the insurer would be happy to like backdate as long as we write that policy or that affidavit says that, yes, I didn't have anything that happened on the 29th or the 28th or whatever. But I was doing some research online knowing that we were going to be talking about these sorts of things and leap years. And I thought, how would this leap year actually affect our statutes of limitations? Because it is more likely that we're going to have car accidents or houses burn or slip and falls or whatever on the 29th of February versus policies getting signed or renewed or whatever on the 29th.
So a calendar year, is 365 days typically,
Mhm.
or it is from February 28th to February 28th. And when you have a leap year, that screws that up. So a policy is written from one date to the next. It doesn't say it's effective for 365 days. It says it's between those dates. I believe that statute of limitations is as well, but I'm not an expert there. So
Yeah. So, fun fact, I want to throw in my fun facts because, I want to be an Egyptologist when I grow up. I'm taking hieroglyphs right now at our local
wow.
community college. Yeah.
Geez.
So the ancient Egyptians were the ones who actually came up with the idea of a leap year. And interestingly enough, here's your fun fact that has nothing to do with insurance. Their year was 360 days. And they believed because that was a nice divided number, blah blah blah, and they believed like these 4 or 5 days were the most dangerous. This is when we have the veil between the underworld and the real world, coming forward. So it was very dangerous. Couldn't do anything on these 4 days. So
Hmm.
that's my little fun fact for
That's
you.
interesting.
Yeah, but
I mean,
they
360 is a much nicer, rounder number.
isn't it? Yeah,
And
it's
I say round kind of like
mm,
tongue in cheek, I guess.
mm.
But that like I'm not an expert on the science of calendars and things like that. I have, very limited knowledge. I have a layman's knowledge of it.
Yeah, but
And
I thought that was very interesting. I mean,
I do,
so because
yeah, it is. It
we
is.
think of those people being ancient Egypt, like, oh, they're not that smart. Well, no, they built the pyramids, and they were the ones who figured out the world was round and 365 days or 365.25, they invented leap year. Anywho,
The world
uh,
is round. We said it. The world is round, people.
oh my God,
Are we gonna get
now we're
flat
gonna start getting
earthers?
trolls.
Oh, we're gonna get some fans now.
Oh, yay. This will be fun. I'm glad we had this conversation. Some of the flat
That's our
earthers.
stance. That's the official stance of the Art of Adjusting podcast is the earth is round.
Yes. Oh my God, this will be so much fun. Okay, so anyway, we were talking about 365 days. The world goes around 365.25, and every 4 years, that 0.25 makes up an extra day, which is what is today is. Anywho, seem like a minor adjustment, but if you have an accident on this day, there are with the statute of limitations, you've got, okay, sometimes you got to do it, make your claim within a year, like Louisiana, or sometimes it's 2 years or 3 years, depending on what state you're in. So, like in Louisiana, the statute of limitations is called a prescriptive period because Napoleonic Code, they're weird. But what I want to point out is that insurers have to stick to this timeline of when they settle a claim, or the policy holder or the claimant, third party claimant, have to file suit to protect their statute or their claim. Brief plug, theartofadjusting.com has first party deadlines and third party deadlines. If you go to property, like theartofadjusting.com, then go to our resources, just real quick plug, you can see that. Anyway,
We'll link to that.
yeah, yes, thank you. This additional day can, in some instances, depending on your state, give you an extra day or give the claimant an extra day to file that claim. So let's say a loss happened on the 29th and 2024, and the statute is usually 3 years or whatever. You could have until March 1st, 2028 to file that claim.
Would you though?
Wouldn't that be 3 years? Is that, no, I'm doing
It
5,
would,
it'd
but
be 7, 2027.
it would be 2027, but would you actually have to, and you have to remember that no good attorney's going to want to have this argument and have, file something this close to the statute. First of
Very
all,
true.
they'll
True.
file it close, but not this close. I don't think.
Oh, you would like to think that's,
You would like,
but you're right. By the way,
but
we're not attorneys. Don't take anything we say seriously.
right.
We're just holding
Um,
ourselves out to be experts, but we both snorted at the same time.
We know a lot about a lot. Hey, we've been able to carry a conversation about policy term
Yes.
for more than 30 minutes now. So I think we're doing pretty good. In New York, the statute of limitations is 3 years for a tort claim. When COVID hit, the courts were closed, and the governor said that the statute of limitations, it was like a freeze on it. I forget what he called it.
Yeah.
And then at some point he reinstated it. So we're back on now. The
Clock starts
hold
ticking.
the hold is over.
Mhm.
So now we as people that are cognizant of the statute of limitations and trying to, determine whether or not something is beyond the statute or not, have to do this weird math where do we add, I think it was 277 days. Do we have to add that to anything that happened within this certain time period? A lot of people were arguing, oh yeah, you do, you have to add that. So now it's 1 year and 277 days or 70, I can't remember the number, but most people I talk to, most attorneys I talk to that are coming up against, the actual 3-year statute, they're not going to risk.
Yeah.
They're not going to comfortably say, well, I have another 276 days. They're just going to file suit. And that's probably the smart move. And this is just, again, not legal advice, but why would you want to get into that kind of that fight?
Argument. Right.
Yeah.
The reason why I say this is I did specifically look up Louisiana and Pennsylvania as examples. And so they said in Pennsylvania, the statute of limitations is 2 years from the date of injury or accident. So the rule excludes that first day. So again, if, for example, if we had February 15th, the clock doesn't start ticking until February 16th. And then it includes the last date of the period to file suit. So that would be February 15th, 2025. Now, it said, does leap year affect the ability to file suit? And of course, our attorneys will always say, oh, it depends. And of course, it depends, because some states say the statute is actually a calendar year, quote unquote, which would include February 29th if that calendar year, such as to this year, is in the calendar. So
Okay.
does leap year affect the ability to file a suit? Well, some say yes, some say no, but I'm going to insert my dad joke. Why take that leap?
Yeah.
See what I
But then-
did?
So I don't see it practically coming to a head in any kind of lawsuit or anything, but who knows?
No.
It's an interesting conversation to have anyway.
I do want to point out a couple of other things that I have seen insurers, meaning the adjusters, do. Subrogation, for example. If we are pursuing subrogation, those timelines affect us as well. So if we're trying to pursue subrogation and the at-fault party isn't paying or anything like that, and our statute is coming up or our prescriptive period is coming up, we do need to file suit against the other insurance company to preserve our claim. And there is something, again, that most adjusters, new adjusters, don't know. And again, it's per state, but you must tell the claimant, sometimes that's the third party claimant, sometimes that's the first party claimant, sometimes it's both the first party and the third party claimant, when the statute of limitations runs. Like you need to tell them, hey, your statute is going to run in 60 days, so you have to sue me.
Mhm.
Or your statute runs in 30 days, you got to sue me. And everybody goes, oh, that's not nice because then they're going to sue us, right? Yeah. I mean, if and in some states, I even read that even if you have an attorney, you have to say that, like remind the attorney. So what I've always done is in my first contact letter, let them know when the statute runs
Mhm.
so that I've told
That's a
them
good
and
idea.
I don't have to worry about because look, if it's been 2 years or a year and a half or something like that, I am so busy concentrating on other things to go back a year and a half to see if I've actually told them before. So I just do it on the first contact letter.
Yeah. Well, one other statute to consider here in the realm of insurance claims is the suit against us provision of the policy. And that is a contractual statute of
Mm,
limitations, meaning that it's buried in your insurance policy, and you're not able to sue your own insurance company after 2 years of the date of loss.
mhm,
And there's been some interesting cases around that, specifically about when the loss occurred. You could have a date of loss for the when the fire started. Then you could have the date of loss of the business income claim, which didn't happen until the Monday after.
mhm,
Or you could have the scenario where you've got separate buildings that all started to burn at a different time. I've seen plenty of arguments around that statute, and
mm,
so the scenarios we're making up here are absolutely possible and probable, and reflect reality
yeah,
in many cases about
yeah.
the arguments that are made to support the statute.
I was going to say it's almost like we're a particular carrier. We've seen a thing or two, so we know a thing or two.
Like I said, I'm not smart enough to make this stuff up.
We are just on fire today. I just have
I
to
know.
say,
I
we're
know.
we're hysterical.
Well, it tells me that you could pick almost any topic related to insurance and we could kill, half hour, 45 minutes easy.
I mean,
So
right? And we're only funny though once every 4 years, though. I would think that.
that's a generous argument, I would say.
Yeah. So I think some of our key points, unless you have anything else that you necessarily want to talk about, is pay attention to our policy period, our time dates, our time limits. I mean, because it's not only those dates that come around. It's going to be very rare that we have a policy that begins on February 29th. It's going to be
Yeah.
rare, but you do have accidents that happen on February 29th. So pay attention to those dates. Pay attention to the times, because like we were talking about, the fire can go over one period into another. How do you split that? If you do split that, there's pros and cons. We've talked about contract of adhesion, and given the insured the benefit of the doubt. What
One
else?
other thing I would say is that when you get a claim assignment, one of the first things you should always do is look at the policy term on that declaration page to make sure you've got the right one, because
Mm,
the coverage may be different from one term to the next.
right.
Limits increase. Sometimes certain coverages get taken off that were there but are no longer there. Various endorsements get added later. So yeah, that's very important.
Yeah, absolutely. Yeah. And remember, as an adjuster yourself, these time limits, they apply to us as well. So if we're pursuing subrogation or something to that effect, and we may need to notify the claimant according to your state.
Mhm.
I do want to mention one thing. I want to give a plug out to Barry Zalma, and we've both talked to him before, both
Yeah,
on,
we got to have him on again.
yes, we do, both on this blog or this podcast when it was the daily claims, and then when we were doing the art of adjusting, I think on Clubhouse. But Barry he's an attorney out of California, and he has updated his book, the Compact Book of Adjusting Property Claims. It is now in the 4th edition, and I meant to grab it before we got on, but I didn't. I think I have the 3rd edition, and it is absolutely fantastic. I use it a lot when I am being an expert witness, which I don't do much anymore, but when I was, I use it a lot because it talks about what the role of the insurance adjuster is. Because if you think about it, we are not mentioned in the policy.
That's right.
And it's very interesting, to think about what our duties are when we aren't in the insurance policy. What the policy says is that you have to cooperate with us, quote unquote, but us is the carrier. And we, as insurance adjusters, are representatives of that carrier, but we're not ever mentioned in that policy. So it's very interesting. He gives some checklists for you to do, especially on fire claims or fraud claims. So I do recommend it. Notes will be in, or links will be in the chat. There's paperback and hardback formulas that you can get, as I think you might even be able to get it as an ebook. So there you
Yes,
go.
it's available as a hardcover, Kindle, or as a paperback.
Awesome. Awesome. Yeah, I dog-eared mine and highlighted and everything. So it's a good book.
It
Next up
covers,
is
it talks about the New York Standard Fire Insurance Policy, which is kind of the foundation for most of the modern insurance policies today.
yeah,
And it talks about some of the basic things that are relevant to every property claim, like the 60 days from the date of loss. You have to submit a sworn statement and proof of loss, and how if you fail to do that, you could lose coverage as a policyholder.
mhm,
So again, these are all date-driven things that, things like a leap year could certainly screw up.
absolutely. I mean, it's almost like I thought about this beforehand.
Almost.
Almost. Speaking of beforehand thinking, guess what our next date will be for our next podcast?
What is it? I don't know. I didn't look.
Pie Day.
Oh man,
We should
that's
eat
great.
pie.
Oh, because it's 3/14.
Yeah. Yeah. So March
Excellent.
14th will be our next one. So I'm gonna drink my tea that I'm always drinking here, and
Yeah.
I might even have a piece of pie.
We're doing another Whole30 diet.
Ugh.
So in March. So I'll have to do something. I won't be able to eat any pie unless I can find a Whole30 approved one, which I don't know that that's a
I
thing.
mean, does your wife watch this? I won't tell if you won't tell.
Oh, she drove the last one. I'm driving this one this time. I'm the one who came up with the idea of doing it in March. So
Oh yeah. Oh,
I'm going to
all
be
right.
the police officer in this one.
Okay. Okay. Well, there you go. So, but we're going to talk about contracts and the insurance policy as a contract, which we've kind of started talking
Mhm.
about with the policy dates and that. But it's always been real important to me that everybody knows how to read and how to interpret a policy, and that contract of adhesion we've just mentioned as well. So I guess these are really good things that we've just started prepping everybody for. So yeah.
In liability insurance, contracts are one of the most important aspects of our investigation, is getting various contracts and seeing what people have promised to do or failed to do under that contract. So yeah, that'd be a very interesting one.
Yeah. So we will see you in 2 weeks.
You
Happy
bet.
leap year, and don't get into any accidents.
Is this going to be 2 weeks or 15 days?
Exactly. See, always thinking. There you go. I'm going to take the leap and say 2 weeks.
Very good.
Okay.
Close enough.
There you go. Bye.
Bye-bye. Thanks for joining us on the Art of Adjusting podcast, where we talk about life as an insurance adjuster.
If you enjoyed this podcast or this episode, please give us 5 stars and a review. It does help the algorithm pick us up.
Hit that subscribe button real quick and tell all of your adjuster friends to check this out as well. For independent adjusting services, go to www.autin.claims. And for anyone interested in working as an independent liability adjuster, go to the Contact Us tab to join our roster.
in the meantime, you can contact me at theartofadjusting.com for consulting and training purposes.